Hello, everyone, and welcome to another episode of the Forge of Freedom podcast. I'm your host, Alex Uli, and this is episode 106 of the Forge of Freedom. Today, I've got an interesting news story for you. It's a case out of Indiana involving NBA basketball player Rajon Rondo. Most people have heard of Rajon Rondo, especially if you follow sports at all. Rajon Rondo played on the Celtics team that won the NBA championship, I believe, in 2008, and then later played on the championship team that with the Los Angeles Lakers, and of course was a star player for the University of Kentucky when he was in college. But Rajon Rondo was recently arrested here in Indiana, near my hometown. As a matter of fact, he was arrested in Jackson County, Indiana. And I'm going to pull up the news story here and walk through the news story just a bit. But then I'm going to get into the police report with you as well, which I'll put up on the screen. Rajon Rondo was apparently driving southbound on Interstate 65 between Indianapolis and Louisville, Kentucky. And there was a report that there was a black Tesla driving in excess of 100 miles per hour. And you can see here, I pulled up this article from WDRB, which says Rajon Rondo was allegedly driving more than 100 miles per hour, weaving through traffic before the arrest. And this was back in January, late January. But he wasn't ultimately stopped for speeding. He was stopped because he didn't have a license plate, apparently, on his vehicle. And when the officer initiated the stop, the officer detected the odor of marijuana, or so the officer says in his report. And that's the next thing I want to pull up here for you is the report, the charges, and then the report. So the officer smells marijuana, says he smells marijuana anyway, asked to search the vehicle and finds a gun and discovers that Rajon Rondo is restrained by a protective order and is therefore in unlawful possession of a firearm under Indiana law and also under federal law. But I'll get more into that here in just a moment. So here I've got in front of you, if you're watching this podcast by video, the probable cause affidavit. And in the probable cause, you can see that on January 28th, 2024, at 2:21 p.m., 1421 hours, the officer was advised of a Tesla traveling at greater than 100 miles per hour without a plate and swerving in and out of traffic on I-65 heading southbound. When the officer found the vehicle, it wasn't speeding, but he observed the Tesla without a plate, and he got behind the vehicle and activated his lights and conducted the stop based on the lack of a license plate. The officer identified Rajon Rondo as the driver. Rondo apparently had his son in the vehicle as well. And it says, after talking to Rondo, the odor of marijuana/cannabis was present, emitting from inside the Tesla. I recognize the odor of marijuana from my training and experience. And this is an interesting issue in and of itself. This is a common tactic used by officers, especially it seems like Indiana State Police officers, to search a vehicle. They allege the odor of marijuana, and that gives them probable cause to search the vehicle. And of course, there is this huge artifice of court opinions built on top of the Fourth Amendment basically gutting the Fourth Amendment and justifying warrantless searches for lots of reasons. One of those is based on contraband that the officer believes to be in a vehicle based on what's called the automobile exception. The idea is that because automobiles are mobile, that there's not time to obtain a warrant because the evidence might disappear based on the movability of the vehicle. So anyway, the other interesting point about this is that the odor of marijuana, well, there are lots of derivatives of marijuana, of hemp. Hemp is legal. Delta 8 is legal. There are things that smell like marijuana and are indistinguishable from marijuana in terms of odor. But nevertheless, courts have said that despite that you can't know for sure that it's marijuana versus hemp or some other product like Delta 8, that still gives the officer probable cause to search. So anyway, that's where the officer, I think that's a horrible opinion. I don't think that, of course, probable cause doesn't have the plain and ordinary meaning that we think it does. I mean, it has the word probable in it, which we would normally think would mean more likely than not. But that's not what probable cause, that's not what the courts have said probable cause means. So anyway, with that in mind, the officer says he smells marijuana. He checks Rondo's information and finds out that Rondo has a protective order that had been issued in August of 2023. So the officer walks back up to the driver's side of the vehicle and asks Rondo to exit the vehicle. Rondo asks if he did something wrong, and the officer says he has to talk to him about some information that was gathered upon approaching the vehicle. Rondo sits down in the officer's vehicle while completing the traffic stop process. And after the officer finished with the report goes on, after Trooper Bush finished with the traffic side of the stop, Trooper Bush read Rondo his Miranda rights from a card, and Rondo waived his rights. The officer asked if there was anything illegal in the vehicle, and Rondo said apparently that there was a little bit of marijuana in a blue container. Another officer arrived to assist, and the officer walked up to the Tesla and asked Rondo's son to exit the vehicle and had him stand next to his father, Rondo Sr., while he was sitting in the police car. The officers searched the vehicle, as I said, based on, first of all, the odor of marijuana, and then subsequently, apparently, Rondo's admission that there was marijuana in the vehicle. And they discovered cannabis and THC gummies, and a pipe with residue, and a gun. And this is the point that I want to talk about as it relates to the Second Amendment. They apparently found a firearm underneath a cup holder in the compartment. It was a P365 9mm, apparently a Sig Sauer, loaded with one in the chamber. And it says, for scene safety, I had Trooper Bush handcuff Rondo behind his back, properly adjust and double lock so Rondo was secure, which is, I think, standard protocol, but interesting since Rondo wasn't in possession of the gun, wasn't near the gun. He was in the police commission, but I'm not here to criticize that action. And after the officer confirmed the protective order, he asked Rondo if he was allowed to have the gun, and Rondo apparently said he was not allowed to have it. And so that leads to the charges that Rondo is facing in Jackson County, which are count 1, unlawful carrying of a handgun, count 2, possession of marijuana, and count 3, possession of paraphernalia. And count 1, and this is the one that I'm most interested in, unlawful carrying of a handgun, is based on having been subject to this protective order that was apparently issued in Kentucky, where Rondo is from. Rondo's originally from Louisville, Kentucky, and apparently he'd gotten into an altercation or some kind of dispute with his girlfriend, and she asked for a protective order, and the court issued a protective order. Well, under federal law and under state law in Indiana, being the subject of a protective order prohibits you from possessing a firearm. And we'll pull up the federal statute here, 18 U.S.C. 922, and it's subsection G8 that we're interested in. And for those of you who have been listening for quite some time, you'll understand why I'm interested in this and why G8 in particular. G8 says it shall be unlawful for any person who is subject to a court order that was issued after a hearing of which such person received actual notice and at which such person had an opportunity to participate, restrains such person from harassing, stalking, or threatening an intimate partner of such person or child of such intimate partner or person, or engaging in other conduct that would place an intimate partner in reasonable fear of bodily injury to the partner or child. In this section, 18 U.S.C. 922 G8, is the section, of course, that's being challenged in the Rahimi case, which is currently before the Supreme Court. Rahimi, that case was heard by the Supreme Court for oral argument in the fall and is set to be decided by the Supreme Court sometime this spring, sometime before the end of June. And Indiana has basically the same statute, but codified under Indiana law. And under Indiana law, you'll see it is, pulling it up here, Indiana Code 35-47-2-1.5, and it's subpart B, which is the part that Rondo is charged under. And I passed it up here. Except as provided in subsections C and D, the following persons may not knowingly or intentionally carry a handgun. And you scroll down, and it says, a person restrained by an order of protection issued under IC, that's Indiana Code 34-26-5, which is essentially the same as 18 U.S.C. 922 G8. So why am I talking about this? Well, as I said earlier, the Supreme Court is considering whether or not Rahimi, who was charged under the federal statute for possessing a firearm while subject to a protective order, whether that federal statute is constitutional in light of the Supreme Court's decision in Bruen, which was issued in June of 2022. And in that case, the Supreme Court said that if a law or government action infringes or implicates the right to keep and bear arms, that the government has to show, and the burden shifts to the government, has to show that the text, history, and tradition of the Second Amendment is consistent with the prohibition that's being defended by the government, that's being used to prosecute the defendant. And they have to show that by analogy. They have to find some analogy in the historical tradition, in the historical record, that is like the current law being trying to be upheld, trying to be enforced. So here, the government in the case of Rahimi and in the case of Rajon Rondo, would have to find a historical analog that prohibits someone subject to a domestic violence restraining order from possessing a firearm. And the question is, how close does that analog have to be? Does it have to be exactly like the current law? Does it have to be a prohibition based on a restraining order? Or can it be something more broad, prohibition based on dangerousness, which is, of course, the argument that the government is making in the Rahimi case. So part of the point of this podcast is twofold. That, number one, after Bruen, there's been a litany of litigation in the federal courts challenging gun control nationwide. But there have also been ramifications, repercussions of the Bruen decision on down to low-level trial courts, even here in Indiana, challenging laws that restrict the right to keep and bear arms and that are not supported by historical tradition. Now, I don't know for sure what the Supreme Court's going to do in the Rahimi case, but Rajon Rondo's challenge here is going to hinge to some extent probably on the Supreme Court's decision in Rahimi. And in fact, Rondo's attorney has filed a motion to dismiss the charge for unlawful possession of a handgun based on the Bruen case, that i.e. that this prohibition in Indiana on possessing a firearm while subject to a protective order is unconstitutional because it's not consistent with the text, history, and tradition of the Second Amendment. And we're in state court. You might be wondering, why is the Second Amendment relevant? Why is Rahimi relevant? Well, the Second Amendment, as the court determined in the McDonald case from 2010, has been incorporated to apply to the states as well. That is, the states are prevented from violating the protection provided by the Second Amendment because the Second Amendment has been determined to apply to state government action, not just federal government action. So the Bruen case, well, I'll go back, Heller and McDonald and later Bruen have repercussions going all the way down to the lowest level trial courts in these state courts. So it's not just the cases that are going to Supreme Court where Bruen is having an effect, as with Rahimi, but it's having an effect for defendants at all levels. Now, I don't know for sure. It'll be interesting to see what the judge does in the Rajon Rondo case. I'll be sure to keep you apprised of that. But it'll be interesting to see what arguments they make, because there are a number of arguments to make here, but without the benefit of knowing what the Supreme Court's going to do in Rahimi, I think they are left with trying to guess where the Supreme Court might land. Nevertheless, the burden here is on the government to uphold the constitutionality of this statute, because clearly the statute implicates the right to keep and bear arms. And what's interesting about these deprivations based on protective orders is that these protective orders are issued based on a lower degree of evidence, a lower standard of proof than what's required in a criminal case. So in a criminal case, before you can be deprived of your freedom, the state has to prove beyond a reasonable doubt that you committed the crime. In these protective orders, in these hearings, if there is a hearing, the court has to be satisfied by a preponderance of the evidence that certain criteria are met. Unfortunately, in reality, these protective orders are often issued as precautionary matters, as a matter of course, with almost no evidence. And so even if the court has a full-blown hearing, each side presents testimony and evidence, and the court determines that a protective order is warranted, it's still only by preponderance of the evidence, which means more likely than not. And so the question partly is it ever appropriate to deprive somebody of a fundamental liberty based on a low standard of proof like the preponderance of evidence? And I think it's difficult. I don't think the government can come up with an analogy from the time of the founding, the time of 1791, or even later years. But the relevant time period, the relevant history was at the time that the Second Amendment was adopted in 1791. And really the only two examples or analogies that are even available are what's called surety laws and affray. And an affray was basically a breach of the peace, but it was a criminal action. And a surety, which is not the same as a protective order, which is a civil action. And a surety is where there was some concern that the person was dangerous, but they weren't permanently deprived of their right to keep and bear arms. They could post a bond, or somebody could post a bond on their behalf, and they could have their right to keep and bear arms back. So neither example is on point with these prohibitions based on the existence of a protective order. So I'm concerned. I don't know, but I suspect that the Supreme Court will not look at it quite so narrowly. I think that they will more broadly look at this concept of dangerousness and say somehow that there's some historical tradition of depriving people of their right to keep and bear arms based on dangerousness. But again, even if you go with a broader concept like dangerousness, what degree of proof is required? And I think that the government is going to be hard-pressed to find any sort of analogy like this. So with that said, Rajon Rondo's found himself in a bit of a predicament here, but he has filed a motion to dismiss based on Second Amendment grounds, and is availing himself of the test that was affirmed really by Bruen. It wasn't created by Bruen. It was affirmed by Bruen and is being utilized nationwide. So this is just a misdemeanor case. Rajon Rondo, his highest level charge is a Class A misdemeanor, which in Indiana carries up to a year in jail. Class B misdemeanor up to 6 months, and a Class C misdemeanor up to 60 days. So this is not a high level charge, but I'm glad to see oftentimes these cases are negotiated through some sort of plea deal because the defendant doesn't have the money to pay an attorney to litigate these issues. But somebody like Rajon Rondo can presumably afford an attorney to litigate these issues. And I'm glad to see that some of these issues are being litigated in state court, not just in federal court. One last thing I want to mention here, I talked about earlier the tendency of courts to sort of uphold government action and to create this artifice of case law on top of the Constitution and the Bill of Rights that in lots of ways guts the Bill of Rights and individual liberty. And I saw this tweet by Clark Neily, who, by the way, was instrumental in part of the Heller case that went to the Supreme Court in 2008. And ultimately, in that case, the court held that the Second Amendment protects an individual right, not just a collective right. It's got nothing to do with this, with participation in the militia per se. It's an individual right. And Clark Neily, he says this: among the worst things government does is advance manifestly pretextual justifications for grossly unconstitutional actions. And the judiciary excels at manufacturing rationalizations for embracing those nakedly pretextual justifications. So here we have a traffic stop that turns into a drug bust, that turns into a gun case. And the courts will jump head over heels to try to uphold the government action here. And as I said earlier, with the smell of marijuana, the odor of marijuana, there's this body of case law that upholds those sorts of actions. And that's a common tactic for getting into vehicles, for searching homes, for invading the privacy of Americans nationwide. So anyway, I hope you learned a little something here. This is an interesting case example in the wake of Bruen. If you haven't already, go back and listen to episode 51, where it's called What is the Second Amendment? And I'll link to that in the show notes, along with a lot of these other resources that I've shared on the screen. But I sort of walk through the history of the Second Amendment and what it means and where it stands today. So go back and listen to that if you're interested in the Second Amendment and where it stands from the perspective of the Supreme Court litigation today. So thanks everybody for tuning in. I hope you enjoyed the show. Of course, always appreciate if you can like and subscribe to help us spread the message of freedom. It helps us with the algorithm. It lets YouTube or Spotify or Apple Podcasts, wherever you're watching this or listening, know that you enjoy the content and that you want to see more content like it. Of course, you can always find us on YouTube, Rumble, Facebook, and just about any of the most popular podcast streaming platforms. You can also find me on X at Forge of Freedom and at theforgeoffreedom.com. Thanks, everybody, and until next time, remember, you are the Forge of Freedom.
Thanks for listening to this episode of Forge of Freedom. Be sure to subscribe wherever you heard this podcast so you never miss a future episode. For more information or to connect with Alex, you can go to forgeoffreedom.com or follow him on Twitter at Forge of Freedom. Until next time, remember, you are the Forge of Freedom.